right, what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
We are federales, you know, the mountain police.
If you're the police, where are your badges?
Badges? We ain't got no badges. We don't need no badges. I don't have to show you any stinking badges.
Before they
Don't get brazen with me.
Oh, accidentally clicked Schrader there. Hey, we got a bonus Schrader. How we all doing? Good morning, good afternoon, good evening, wherever you are, whatever you're doing, whatever time it is, whoever you're doing it with, and however awesome it may feel. Welcome. How are you doing? I'm here. A little bit disappointed though. I seem to have somewhere in the grand scheme of things misplaced my my green flat cap. I was going to go like full green today. We've got the red breast, which is ironically in a green bottle. We got the green Eddie Bauer shirt. We're going to put on a green flat cap. Got the green watch on. You know, I was thinking about going green today, but seem to have misplaced a hat. I haven't seen it for a while, so it could very well have been left somewhere in a bar, in a taxi. It could have been left anywhere. It's been a while since we've seen y'all. Since the judgment a little earlier on in my morning, like way earlier in my morning. I think it was like around 6 o'clock this morning. So what are we going to be doing today? Today we're going to be going back and looking over the case. We're going to be looking at a few things. The main things I want to do is look at the opening statements and to see if you think both sides did what they set out to do in their opening statements. And then look at the jury instructions to see if we can see how and why the jury reached their decision based on the law as was explained to them by the judge. Hey, Barney Young, hate losing hats when drunk. I don't think I lost it when I was drunk. I'm just saying that I've probably given umbrellas to like half of the taxi drivers in Busan. You know, I just leave things in taxis, hats among them, hats, umbrellas, things like that. In you know, restaurants, if I leave them in bars, it's because I'm drunk. But anyway, the hat just isn't where it should be. Hopefully it's somewhere in the house, but it's not. Anyway, we're not here to talk about my hat. Right. So that's what we got on the menu today. We'll do this for probably our usual 90 minutes to 2 hour stream. I almost said 90-hour stream. That ain't going to happen. The housekeeping stuff, we are set to go. Currently, right now we are sitting at 35,987 subscribers. We've lost a few more since yesterday. But as I said, this month is just flatlined. YouTube just does this thing where YouTube giveth and YouTube taketh away kind of stuff. It's been flatlined. I think so for like the last 30 days, I'm almost at a zero. Even though I've gained a bunch, I lost a bunch. Kind of like you make a lot of money, you spend a lot of money. Frosted Sleet. I heard this guy had a federal case after this one. Do you know why? Yes, we read his federal indictment at the end of last stream. Basically using his badge to kidnap at least 2 prostitutes and force them into sexual relations. Oh, there we go. We've lost this stream real quick already. Force them to have intimate relations with him in exchange for being released and not arrested, and tampering with several witnesses and lying to the FBI. So his trial is supposed to start in July, the federal trial. Oh, and we have 20 gifted memberships from Tank Rat. Tank Rat back in the house. Hey, Tank Rat, it's been a while. How you doing, brother? Every one of you big old 20 people that got that gifted 20 Legal Vices membership, give a special shout out and thanks to Tank Rat. Thank you. That's deeply appreciated. And we've also started with the first $5 super chat, $95 on the way to the bonus doggo cam. Marv White. Is it 420 there yet? Legal vices. 90 more minutes until it is the 20th of April. Yeah, all this 420 stuff doesn't happen in Korea because you go to jail for a very long time. So that doesn't happen here. So all right. It's good to see everybody. Good to see the mods here. Mods, you're always doing your thing, always looking good. Chat, as always, you are super awesome. So please stay super awesome. We've got our like and subscribe poll, which is just kind of basic and self-serving, as it always is. Like the likes are important, but it's also important. The subscriptions are important. Now, I kind of want to break out of this stupid little YouTube hell loop they've got me put in. I hit the like and subscribe is the beginning of the poll, but especially the subscribe because I want to get you back to 36,000 subs, to get you to 37,000 subs, to get you to 50,000 subs, and settle down there. Just keep it real. Get back to 36,000 first. And there we are. That's the poll today. Just reminding you to double check to make sure you're still subscribed, and we'll see how things go. But as I said, I want to look first at the opening statements of both sides. And with the time that's left over, we'll look at the jury instructions. Tomorrow will be O.J. Simpson Day. Good to be back to O.J. Simpson Day. Friday, we'll probably do a little legal news roundups, maybe some funner, fluffier stuff. Not fluffer stuff, fluffier stuff. Any fluffer stuff here. That doesn't happen. Probably a Friday night stream. I kind of like doing the Friday night stream because that lets me have a Friday night, and then I just have to make sure I can wake up on Saturday morning, do the stream, and then that's kind of it. So it'll probably be a Friday night stream for U.S. stuff. Right. So where are we at in the whole grand scheme of things? Spoiler alert to all of you who didn't see the stream about 14 hours ago. The jury took 4 hours to reach their decision. After 4 hours of deliberation, they came back with not guilty of murder and not guilty of voluntary manslaughter. And particularly in this case, I'm not going to say they found him innocent or he is innocent. I don't think he's that innocent, but not guilty, I believe, was the correct verdict based on the evidence as presented by the prosecution and defense. And that's what we want to look at here. So, as always, don't forget for the 400th time to hit that like and subscribe button. Take our like and subscribe poll. Super chats are not required. There is no minimum super chat required to speak with yours truly. Every super chat gets read. Every super chat is gratefully accepted and graciously accepted because it's you parting with your hard-earned money to show your support. And those of you that can't, don't want to, or otherwise, not expected, not mandatory. I'm still glad you're here. And that's it. I don't have anything else to do just yet. I know of course I'm underrated, for God's sake. I'm one of the most underrated people on planet Earth. But I'm also one of the most humble. I just got back from watching John Wick 4, so I'm still kind of pumped up. That was a good film. I needed the catharsis of just like watching a bunch of people get shot. I mean, it's kind of sad saying that on the tail end of this trial, but I needed to live vicariously through John Wick for 3 hours. All right, I am now bringing up the oldie stream. Boom. There we go. Here we are. How are you? This is the opening statements of the prosecution, and we'll stop and talk and stop and talk and stop and talk. Yeah. Legal vices, phrasing.
Phrasing?
That movie makes me want to get a Stairmaster. It makes me never want to go on stairs again. Because I'm not coordinated. All right, here we go. And remember, as always, the court audio kind of sucks. So let's see how we go. I can't remember what day one.
6-2, State of Ohio was.
They kind of got their audio worked out on the last day.
What we're going to do now is do opening statements, and after opening statements, you're going to go on a jury view. Is there any opening statements on behalf of the State of Ohio?
All right, go State of Ohio. Go Buckeyes.
On August 23rd, 2018, Donna Castleberry, a 23-year-old mother of two,
Okay, fact.
was on the west side of Columbus here in Franklin County when she encountered the defendant. He was working undercover. He picked her up, suspecting prostitution. Donna.
Okay. That's different. That was, I think, the last time they ever said that. The rest of the entire trial, it was he was trying to kidnap her, or anyway. That's
had taken to prostitution after recently battling a drug addiction.
Recently battling a drug addiction. That implies that she had gotten herself clean, recently battled. Unless she's implying, which I don't think she is, that she gave up the battle because she had cocaine, fentanyl, and a horse drug in her system. A horse tranquilizer in her system.
She came up to the car. They engaged in conversation. Donna got into the front seat of the vehicle. They began small talk, and they decided upon a price for sexual acts.
Yeah, she
At that
actually
point, the defendant
uptalked
drove
her
onto a lot near an apartment building that you will later see, drove around to the side and parked up against the side of that building, parking so that her door, her side of the car, was right up against the building so that she couldn't open the door and get out. The car was also equipped with child locks, so she had no way to exit the vehicle.
Which you would want in a situation like that. There's a reason the child locks are engaged. And if it's a marked police car, I don't know how many of you have ever been in the back of a police car or noticed, but inside of police cars, they don't have door handles on the inside because you don't want your suspect to get out and start running. Yeah, so there's a reason. There's a reason that the child locks are engaged and marked cars don't have door handles.
After he stopped the car, he told her he was a police officer and she was under arrest. Donna asked to see some identification. He showed her a plastic identification card. She said, "Where's your badge?" He said, "I don't have it. I forgot it." She wanted more proof. She asked, "Where's your walkie-talkie?" He claimed that was in the trunk. It was not.
Okay, that was the first time she implied he was a liar. Oh, sorry. Didn't mean to kick you in the face, Strawberry. I didn't know you were under my desk. Sorry.
She was polite. You'll hear her demeanor because there was an audio recording. The Columbus police at that time would take a cell phone line or some sort of recording device and place it in a hidden spot, typically in the door, and record the conversation to get the elements for prostitution for later use in court.
Mm-hmm.
So you'll hear her demeanor. You'll hear her asking for proof that he was a police officer. She said, "I know how Vice works, and I've never had it happen this way." She wanted more proof from him. He said, "I'll text my buddy." That's what he said. Got his phone out and sent a text out to his team who was away working on an arrest on another prostitute. She sat there. Nothing was happening. No cruisers were coming. No additional proof was offered. So she sat politely waiting.
Okay, this is different. In her closing, she was arguing that that he couldn't wait. He was waiting. There he said he was waiting. Everybody was waiting. Nothing was happening. And in her closing, she was saying he wasn't patient. He didn't wait. He could have waited. So that's a little bit different. So now she's saying her client got impatient here. Her client was the one. Well, not her client. That's no, that ain't gonna happen. It's not her. Not her. It's the state. So in her argument, this argument, she is saying that they were waiting, nothing was happening, so she got nervous or got worried or whatever's going to come out of her mouth next. But in the closing statements, she was arguing that it was the police officer who just couldn't wait any longer.
The two sat there in the car. A bystander A fellow came out of that apartment building. He walked behind the car. He was walking to a dumpster. She took the opportunity. She rolled down the window and she decided to yell to that bystander for help. And as you'll hear from that audio, this is when the defendant got mad.
Okay, so that's a pretty straightforward recitation of the facts at the beginning. Couple of discrepancies, couple of misleading things, I think, but nothing too serious. Brad says, why didn't they put the bystander on the stand? They don't know where he is. One of the witnesses has no idea where he's at.
Can you help me? Can you help me, please?
Help you what?
I'm a police woman.
I am the police.
Okay, that's a we can talk about the video later, I guess, but I think that's a rational response from the police officer. Who's like, he's doing his business, he's waiting, he's taking his time, waiting for the other people to show up, like he said, and now she's hollering. She was the one that couldn't wait. She was the one that had to do it, and then you get to a point where she starts wanting to bring third persons into this, third party. She wants to bring a citizen into this, and maybe that's a citizen who has something against a policeman. Maybe he tries to white knight because he doesn't believe the guy's a policeman, and he starts to do something to the police officer, and that guy gets shot. So she has complicated the situation by hollering to someone else for help. Hey, Chandler, what's up? Okay, so they want to go and have a discussion about that, which they do.
That's the only way we can do it.
Can you help me, please?
Help you what?
I'm a police woman.
I am the police.
I know you're not the police.
He's trapping me and saying he's a police officer and he's not a police officer.
He's trapping me and saying he's a police officer, but he's not a police officer.
Yes, I am.
He's acting like he's a police officer. And he's not. And he has this in a fake ass bag.
Okay, so there she's not telling the truth. She says he has this fake ass badge. He showed her his ID card. Yeah, no spoilers. Hey, Nicholas. Cute little photo icon-y thingamajigger you got over there. So, all right. He's a fake ass cop that's got a fake ass badge. Even though it wasn't a badge, it was a ID card.
Kidnapping women. I've already heard about him.
He's kidnapping women. We've already heard about him. She's not wrong. She's not wrong. You have to give her that. Seeing as how that's what he's still in jail for in the federal level, she was not wrong about that statement. He just wasn't doing it at that point in time.
One is this possible to show me a picture. You know that, right?
Yeah.
They will show me a picture. Don't put your hands on me. Don't put your hands on me. Do not put your hands on me.
It's Trenton says plastic card instead of a badge. I don't see that as an inconsistent claim. Well, she's already asked, where is your badge? He says, I don't have the badge. And he shows his ID card. She knows that's not a badge. She knows it's not a badge. She knows it's an ID card because he's already told her, I don't have my badge. And then soon as somebody walks by, she says he's got a fake ass badge. So yeah, I see that as a very inconsistent thing for her to say. If he hadn't seen the badge, if she hadn't talked about the badge, I could see you saying the same thing. But is it a perception thing if she's already said, she said, let me see your badge. I don't have my badge. I have the ID card. And then she says, he's got a fake ass badge. She could have just said he didn't bring his badge. He doesn't have his badge on him. Anyway, I think that was kind of a problem. And she's, that kind of lends a little bit of credence or credibility to the fact that maybe she was just trying to get attention or to try to get out of it somehow by involving the public, by exaggerating some claims. I don't know, but I think that that was a mistake on her part.
Do not put your hands on me. Don't put your hand on me. No! No!
She's got a knife.
No!
Okay, so that's where she's got a knife. She cut me. So that's already there.
No! Get off of me!
Just cut me.
No! No! Help me, please. I'm in the back door. Help me. I'm in the back door. These guys got me.
And again, I mean, remember she's got 3 major drugs in her system at this point in time. Now, if he was doing something that was overly aggressive with her or looked shady and the guy who was walking by just ignored it, he's an a-hole. Or he could have looked and goes, okay, yeah, she's just a nut screaming in the back seat. We don't know because he's not there. They don't know what happened to the guy that walked by. He can't say what they were doing in the car when he was there, which is a problem on the part of the police and the prosecution. They didn't keep track of the only guy that could corroborate the statement of either side.
Please help me. Please help me.
Fucking nightmare.
All right, that was the audio. He was trying to arrest her. He said, I'm putting you under arrest. She didn't believe it. He said, okay, we'll wait for the other people. Well, you texted someone to come. They were waiting. The third party guy walked by. Then she started inviting the third party guy, this other guy walking by, into the equation. He said, F it, I'm going to arrest you. And he tried to put handcuffs on her. She grabbed the hand. She sliced him wide open with a knife on his hand, 34 stitches, emergency flashback, and threw the handcuffs out the window. And he says he feared for his life, and so he grabbed his service weapon and shot her. And that's what we're here to decide. Well, the jury already decided.
To Donna Castleberry.
That was her last words.
You will have the benefit of the entire audio from start to finish that was synced up with the building video. It's not great video. It's from an older system, but it shows the car and you can see movement patterns in that car. And that video was synced by somebody from the Organized Crime Commission, an expert, put the audio with the video to try to lend some additional evidence here. And that was done at the request of my office, not the Columbus Police. You'll
Okay, so
see
the prosecutor requested the sync up.
when you look at that during the shooting, the car door was open and Donna Castleberry was in the backseat of that car.
Okay, that's accurate.
The defendant's charged with murder and voluntary manslaughter. These are two options for your consideration. We'll get into this more later, but just generally, murder is that he caused the death of Donna Castleberry as a proximate result of committing a felonious assault, which is basically discharging the firearm, knowingly causing serious physical harm. Voluntary manslaughter, while under the influence of a sudden passion or in a sudden fit of rage brought on by provocation occasioned by Donna Castleberry, reasonably sufficient to incite him into using deadly force, knowingly caused Donna's death. Now, the defendant has asserted, as you've heard in voir dire, that he was justified. He claims he reasonably believes she posed an immediate threat of serious physical harm to him. And the judge will tell you, officers are forced to make split-second decisions in rapidly evolving situations.
Okay.
And we don't dispute that, but this was not a split-second decision.
Okay, and this is one of the good points that the prosecution made. This wasn't a split-second decision.
This was not an officer firing to save his life. This was not an immediate threat. We will present expert testimony on this topic. And I want you to pay close attention to the timing of the shots. You heard them, the pop, pop on that tape. The first shot was fired approximately 47 seconds after the defendant yelled, "She has a knife." Then he yelled he was cut 2 seconds later. So 45 seconds till the first shot. Cut by a woman who we assert did so in a defensive manner.
And that may very well be true. So I don't have any problem with that statement. If for some reason she was in fear, whether she was reasonably in fear or unreasonably in fear, if she was in fear that she was being kidnapped or raped or whatever, I have no problem with her saying she acted in self-defense. If she lived, it may have been something she would have to prove in court. But okay, let's give the benefit of the doubt. She, for whatever reason, whether it was justified or not, thought that something bad was going to happen to her. So in her mind, she acted in self-defense. Again, right or wrong, justified or unjustifiable, let's give her the benefit of the doubt that she acted in self-defense. What she believed to be self-defense. I can give that ground.
Cut by a woman who we assert did so in a defensive manner. Not by an attacker, not by somebody being aggressive. He did sustain a large slice to his hand. We don't dispute that. How it happened, we don't specifically know. But Donna was screaming for help. She was screaming for a passerby to call the police, call 911.
Yes.
She was begging, "Help me, help me." She was scared of him. She believed she was being trapped in a car.
Now, again, we can interpret that however we interpret that. She could have been yelling for help. She could have been desperately trying to get someone to call the real police. Or she could have been faking it, trying to get attention, trying to, get him to let her out or whatever. It could have been for any reason. The way to handle this from the prosecutor's position would have been not to lose track of the guy that was standing there.
By somebody who was trying to rape or harm her. Her actions were defensive and only began after he put his hands on her.
As a police officer is justified in doing.
She was trying to get away. She was trying to get help. She wasn't a threat when she was trapped in the back of that car with no way out. If she'd been a threat, I submit the defendant would have sustained far more wounds. And as you will hear during this trial, he sustained a cut to his hand and another small cut. No further injuries, no documented injuries of any other sort.
Yeah, other than the one that he described as slicing from the top of his thumb all the way down over here that required 37 stitches and apparently an emergency blood transfusion to save his life. That's a pretty significant injury. She's kind of trying to downplay it, which it's what she should do, because it's a bad enough injury that you're gonna want to play it down as much as you possibly can to make it look like it was no big deal.
No knife slashes in that car. He fired 6 shots over the course of nearly 12 seconds. And you will hear that officers typically fire 1 shot. Typically fire in 1 second 4 to 6 shots. Could fire 4 to 6 shots in a second. Officers also have a duty to assess and reassess and account for every bullet they fire.
Okay, every bullet they fired was accounted for.
Indicative of an officer firing to save his life and facing an immediate threat.
And that's a good argument. I think that was their best argument. I think that was the prosecution's best argument, was that it took him the 12 seconds to shoot the 6 shots. And he's saying that wasn't justified. It was too long. It wasn't just a, bang, 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 you're gone kind of a thing. But the only people that could testify to that, we don't know where the other guy was, where Mr. Passerby was at that point. He could have just already gone. Let's assume that they're the only 2 people there. The victim, the dead woman, and the police officer. What they would have had to have done is put on a witness that was able to give an expert opinion on the rate of fire of police officers and the stress of the situation, how that affects. They put their expert on. The problem was he just kind of sucked. I was pro prosecution. I was on the prosecution side until they put their use of force expert on, the old guy that looked like Hal Holbrook. And listening to his testimony, that was what made me change. So that's what they should have done. Should have had a better witness, because that was a battle of the witnesses. This issue, I think, came down to a battle of the witnesses, and the defense's witness ran circles around not only the prosecution's witness, but also her.
As you'll see from the video, he'd been cut more than about 45 seconds prior, before the shots. He had time, as you will hear, to release his seatbelt, to open his door, to push that door open in some fashion because it was found open, to reach down between the seats for his gun that was in a holster, to pull the holster out, to pull the gun from the holster, and as you'll see in the video, to at least get a foot out of the car, to pivot, to turn, and to fire at her in the back seat. There is no evidence Donna Castleberry had a knife when she was in the back seat. His own statements will
Okay, this is the interesting thing, and this is kind of where I think some people have the disconnect. They're saying there's no evidence that she had a knife when he was in the back seat. Frankly, from a legal perspective, it does not matter whether she actually had a knife in the back seat or not. It doesn't matter if there was a knife in the back seat or not. It matters what he thought at the time. If he reasonably believed she still had that knife in her hand, that makes what he did a justified thing. And that was something that the defense expert raised, was they keep saying the knife is... Oh, yeah, we'll get to that, Brad. We'll get to that. So I lost my train of thought. Dang it. Oh yeah, so it's not what actually occurred, and their defense expert, which we're going to try to take a look at, said that the knife they said was on the driver's seat was in a different position in some of the other photographs. Now, she's saying that, yeah, and they said this through a lot of the testimony, that there was no threat because You know, she didn't have the knife before she went in the back of the seat. We do not know when that knife was dropped. We don't know where it was dropped. And as Brad has so astutely pointed out, at some point they said there was there was another knife in the back of the cop car. So again, that kind of proves the point here. Even if the cop doesn't believe she had her knife in his hand, he knows there was a knife in the back that maybe she could see, maybe she would get. So that actually bringing up that extra knife in the back seat kind of goes to support the officer's reasonable belief that she still posed a threat in the back seat. Just some food for thought. But I think she's doing a pretty good job of laying out their theory of the case here. And I think more should have been done. More emphasis should have been put on that, on the 12 seconds and the 6 shots. Hugh Neutron, I was on the prosecution side at the beginning of this. The prosecution's expert witness changed my mind. As I said at the time, the prosecution's defense expert, the use of force expert, was one of, if not the best witness for the defense. The prosecution's witness, their expert, was one of the best witnesses for the defense.
Reflect that he never saw her with a knife in the back.
Now she's saying that was his statement. I don't recall that in his statement, whether I think he said he doesn't remember seeing the knife, I think is what he said.
Seat. The knife was found on his seat, was found on the front driver's seat of that car.
Well, that's where it was in the picture. It was argued that it was somewhere else. Now, again, see, Brad says agree, focus on the 12 seconds and the threat change halfway through. See, 12 seconds is a long ass time. I mean, it would be, I don't know. I can't remember what the cadence was, but we'll just do it every 2 seconds. So it'd be like bang, 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 bang. That's a long ass time. They should, I would have done that. I would have said this was the cadence and hammered it out and said and explained what he could have been doing during that time. But they didn't.
Officers are permitted to protect themselves.
Yes.
And use force when reasonably necessary and when they're confronted with an immediate threat. But as you will see, Donna was not an immediate threat. Any threat was over. And as you'll see from that video, the door was open during the entire time he was firing, giving him time to create distance or to contain any threat.
Okay, that I don't think is a good thing. Let's go back and listen to that. I got a problem with that.
Firing, giving him.
I gotta go back a little more.
During the entire time he was firing.
During the entire time he was firing.
Time to create distance or to contain any threat.
Or to contain a threat. During the time he was firing, he could have contained the threat. I don't like that because, that's implying you go bang. Okay, and you try to roast it, go, okay, bang, and then you keep trying to fight, and you go bang. I don't think, you're not trying to contain a threat at the time you start firing. You're trying to stop the threat.
We understand officers generally confront a threat, but there are circumstances where officers are tasked with saving lives, with assessing, with reassessing, with taking measures to avoid taking a life. He had the ability to create distance from her. She was in the back seat, trapped in that vehicle.
Thank you, Corn.
He had a door open. Instead, he turned back into that vehicle, and began firing at her in that back seat.
I have a thought about that, and I don't think anybody testified yes or no to this. And I was thinking this because when I was watching this testimony, I was thinking, I did this. I've done this before a few times, and it's embarrassing as shit when you do it. You're sitting there, you're doing something, you stop the car, you turn your car off, you text somebody, you're doing something on your phone, you're talking on the phone maybe, and then you go to get out of the car, you open the door, you go to step out, and you're like, oh, fuck, I still got the seatbelt on. I don't think there was any testimony from either side as to when he took the seatbelt off. So this is just me thinking out loud. I wonder if there was a possibility that maybe he was trying to get out of the car, but he had forgotten to take his seatbelt off and got stuck up and could only get one foot out of the car and then had to turn and go, okay, I'm stuck. There she's got that knife and that can happen. My only problem with that is I think if it would have happened that way, if he wouldn't have gotten the seatbelt off, he would have forgotten the seatbelt was on and got that, he would have made a big deal about it when he was on the stand. He had his belt off before they stopped. Nice one, Valhalla. John Quinn says, Steven Crowder is on. Nobody's keeping you here. On Crowder, go to Crowder. We're here. This is where the fun is. Or he was trapped inside a car with a murderous drug-fueled maniac. That's a possibility as well. MG Law says the prosecutor knows what she is saying and knows that it is the wrong analysis of how he should have acted. She's playing the game prosecutors play to try and get a conviction. I will agree with that. And on this, to be fair and balanced, by the same token, defense lawyers, they also play the games that the defense lawyers play to try and get an acquittal. That's why I don't really have a lot of problems with a lot of the game playing that goes on for both sides in their opening statements.
She was hit by 3 of those bullets.
All right, well, we'll talk about that in a second.
The defendant here, he got angry. His decision.
Okay. Again, this is another problem with the prosecution's case. And it may have been that there's just no way that they could determine or prove which of these 6 rounds were fired when. Hey, Legal Mindset, what's up? Crowder's entire fucking game is weak compared to me. Just saying. Except for maybe his humility game. I'm not very humble. So yeah, there was the 6 shots fired. 3 of the shots hit her. Now we don't know which shot went where, which was first, second, third, fourth, fifth, or 6th, which ones hit her or in what order. So there was one shot that he shot through his own headrest, through the sidewall of the car and into the tire, which punctured the driver's side rear tire. One went through the roof and one went directly through the back seat into the trunk and into a plastic basket that was back there. One went into her calf, out her calf, and into her thigh. One went into her torso and stayed there. One went into her torso and went through. It's quite possible it could have gone in any order, where the first 3 shots miss. The 4th one goes through the leg, which would likely not stop a deadly force thing. And the 2nd one and maybe the 5th one and the 6th one were the ones that stopped the threat. The prosecution didn't lay that out for us. They didn't. And so, as I said, it's quite possible, it's quite probable that they couldn't do that. There wasn't evidence of, there was no way of figuring it out, which is a huge weakness for the prosecution. Huge. All right, let's go.
Based on the fact, not that she presented an immediate threat, but that he'd been cut. This wasn't a legally justifiable use of force. The shot
right.
cadence here, 12 seconds to fire 6 shots, is not consistent with an officer firing to save his life. It's retribution.
Again, pound it out. Give us example of the timing of those shots.
Thank you, Your Honor.
Okay, that was the opening statement from the prosecutor. I'll say that I think she did a good job of, at the beginning, giving a fair recitation of the facts. I think she did a fair job of presenting their theory of the case. As far as engaging and being dynamic in a way that's interesting and demonstrative, I think she did poorly. Like I said, I think it would have been much better to hear that cadence, that shot cadence tapped out. And I can't remember how many seconds were between each of the shots, as she said in her closing statements. But I think there was like one point when there was 4 seconds between shots. That's when you just go bang, 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 bang. You emphasize how long. People think 12 seconds is really short. Just walk up to a stranger and stare them in the eye for 12 seconds and see how freaking uncomfortable and probably poorly outcomed that. 12 seconds is a long time. It really is. The prosecution, I think, dropped the ball there. They could have explained a lot of things that could have happened in that 4 seconds or however many seconds, but they didn't. So, I mean, overall, I would give her a good solid B to a B plus for her opening. I remember thinking, yeah, that sounds reasonable, and being on their side, they put their witness on, and then thinking, yeah, no. And I actually thought her opening was much worse than it actually turned out to be. In retrospect, yeah, okay, I said I'll give her a good solid B, B plus. Now we get Lisa Simpson here. Just close your eyes and tell me this is not Lisa Simpson.
May it please the court, Mr. Collins, Mr. Mitchell, Miss Pritchard, Mr. Cable. Good morning, ladies and gentlemen.
Like how she bows to the jury.
Miss Pritchard just told you that Miss Castleberry was not an immediate threat. Now, her own witnesses are going to tell you differently. So keep that in the back of your mind as you listen to the state's testimony.
Okay, the one thing I don't like about her delivery is I'm not a big fan of the stand there and be grumpy with your arms folded like the prosecution did, but I'm also not a big fan of the waving your arms around like an Italian on steroids. She's a little too wavy and pointy, and continually pointing at the prosecutor with like the 5-finger death punch. That looks a little kind of scripted, a little acted to me. It doesn't seem natural.
She just tried to tell you that Miss Castleberry was not an immediate threat. Yet on August 23rd, 2018, Donna Castleberry was under lawful arrest.
That is absolutely true. She was under lawful arrest. And again, that's something that we have to keep in mind. He was undercover. He was following procedures precisely. He wasn't required to have a badge. He wasn't required by policy to have a walkie-talkie. He wasn't required to be wearing a uniform. He wasn't required to be in a marked car. He was an undercover cop doing his job. The fact she didn't believe him is her problem from his point of view. Once he says the magic words, "You're under arrest," it's basically on until they're taken into custody, handcuffed. And that was her mistake. And unfortunately, it cost her life. But he was doing his job. She was under arrest, and she was resisting that arrest. And before we get too far afield here, I want to make a couple of chats here. Doggo Cam, Yoda, Megapint. Thank you, Bella Stella. That is deeply appreciated, and it's going towards Doggo Fun. Flux, I don't know. The first victim got off easy, just a blowy. Yeah, that's the ones that's on the one of the federal indictments. It escalated from that to the other. The second victim, she didn't get off quite so well. I doubt she got off at all. But you know, she suffered a lot more allegedly. So we've got Doggo Cam there. We need to adjust accordingly. There we go. Doggo Cam adjustment complete. To be Flair says, and prey upon vulnerable people who are misguided. I wholeheartedly believe this guy did just that, but I don't think the state presented the evidence for conviction in this case. That's kind of how I'm seeing it myself. Given her at Legal Vices, do we have the body cam footage of the knife in a different position from the still photo? We're gonna have to look at that. We'll look at the evidence, the pictures that were taken from inside the car, and see if we can see that on any of the pictures that we've seen. But that was what the state's use of force defense witness said. That's what the defendant's use of force witness said. That the picture that they were showing wasn't the way he saw it in other pictures. That the knife had been moved and posed for picture taking purposes, which cops do. Cops do. John Gary says, I think the disconnect with those who think he's guilty is believing the victim needs to give the attacker way more benefit of the doubt before responding with deadly force than the law requires. Okay, I see what you're saying there. Yeah, you know, you don't. So if someone's attacking you, you don't have to give them any benefit of the doubt before responding with deadly force in certain cases. You know, that's an Andrew Branca issue for the details of that. You have to meet the 5 requirements to use deadly force. And once those things are met, you don't have to do anything other than defend yourself. Kale Hyun 2, Legal Vices, did you say that the call girls around the area basically says she lied? Okay. That is an interesting thing. And I think she was telling the truth there, that word is going around that it's you're kidnapping people. We've seen pictures. She was right, actually, it turns out. But the police detectives, they said, oh, we listened to her because she's saying, I know it was you. I know you're kidnapping people. They listened to her and they went to talk to other prosies on the street and asked these other prosies if they heard any rumors about somebody kidnapping hookers and of course the streetwalkers are going to say no. The guy was a police officer, and if the rumors were out there, it would have been he was a police officer, looks like this guy, and he flashes his badge and makes you do naughty things in order to get released from arrest. They're not going to, a cop comes up and says, is there a dude doing this? They're not going to say, oh yeah, it was another cop that did it. Of course the prostitutes aren't going to be talking to the police and pointing a finger at one of their own. So again, I think that was a bad state of affairs. If some of the if there was a rumor out there, and if some of the prosies had heard it and had said something, who knows? I mean, it would have been too late at that point. I mean, because the girl was dead already. But could have given some more things to throw at this, and more evidence that this guy was doing bad stuff and people knew about it. It's an unfortunate thing. AC guy. He's guilty because it's obvious AF. He's not in any real danger. See, you keep saying that, and I can't really see that. You can't. I don't know how you can say it's obvious he's not in any real danger, and he could have simply got out of the car when she has already opened him up twice with a knife. It's pretty obvious to me that she was a danger. It's just when that danger ended, when that threat of danger ended. The jury, all 12 of them unanimously thought it didn't end until she ended. So yeah, he said he could have simply gotten out of the car. And if he thinks she still has that knife, if he still reasonably believes she has that knife, and he turns and goes through all the motions of getting out of the car, and he mentioned that in his testimony, he was convinced that he was going to get at least he could have got stabbed again while trying to do anything, but he decided to, let her go because he was being choked out, whether you believe that or not. He let her go and reached for his service weapon, and he expected to be stabbed during that motion, but that's what he did. So I don't think it's obvious AF. If it was obvious AF, I think the verdict would have been different. And Brad said, okay, we already talked about the other knife in the back seat of the car. All right. All right, let's continue. We got those out of the way, got Doggo Cam adjusted. We are good to go with more opening statement analysis.
She failed to comply with that lawful arrest.
The arrest was 100% lawful, and she completely and obviously did fail to comply.
Resisted that lawful arrest. The evidence will show that she attacked my client with a knife. Now, conveniently, what Miss Pritchard didn't tell you was then that she proceeded to choke my client. That threat never stopped, ladies and gentlemen.
And I think that's the weakest part of the defense's case. I think that's the weakest part of the case, to say this five something. She was 110 pounds. And he's obviously a much bigger dude. She'd put she'd put her foot up on his throat and was pressing it, and he almost lost consciousness. I don't really believe that. I think it's, and the DNA on the bottom of her shoe, it was his freaking car. And again, it could have come from his neck. It could have come from the floor. It could have come from his hand while he's trying to bat her away from to stop her from kicking him. That's what I thought. Red Eye Good 5-5. That's what I thought. I just didn't want to say it. But so, yeah, I think this is the weakest argument. And they spent, I think, too much time on it. I think that was very, very dangerous for the defense to do that. Because, all of us, even the ones that think the verdict was correct, we're listening to that going, yeah, that doesn't sound exactly right. It seems a little bit fishy. And I don't think it was necessary. And you can say, I was holding her hands. I was stopping her from this. She kept kicking me. And I just said, okay, I need to stop this. And I thought I was going to get stabbed while I was reaching for my gun, but I had no other choice because we'd reached a stalemate. I don't think you needed to go with the shoe thing. I thought it was really, really dangerous and probably not accurate. But yeah, Chandler says they found his DNA on her sandal. He said it could have come from his neck. It could have come from his arm. It could have come from his hand slapping the feet away. It could have come from the floor of his car. We just don't know. And that's why I thought it was very, very risky to say that. But why would he make up the choke when he has the knife wound? That's the thing that police do often. They have somebody dead to rights, and they decide they're going to make the story a little bit better. It happens. So I don't, even if it's true, I thought it was risky.
Up until a split second before he lost consciousness, when my client's training kicked in, and he knew at that point.
I called BS on this the first time it came through, and I'm calling BS on it the second time through these opening statements. D there says legalizes seriously when the prosecution doesn't even show you one theory with proof backing up reasonable doubt, especially if they propose multiple theories like we don't know. Yeah, that was one thing that they kind of did through their course. They didn't stick to one theory, which they should have. I don't want the prosecutor giving me options as to what possibly happened, because only one of those or none of those could have happened, and it's their job to remove that doubt. If they say this could have happened or this could have happened, you say, okay, yeah, that's reasonable doubt. We don't know which one happened. You can't say something happened and it was either this or this. Legal vices serious. Oh, we just read that one. That wasn't what I was going to read this one. JSDs. Legal vices disagree. There is some small there is some small people that are way stronger than they look. Criminals come in all sizes and shapes, especially when they have a weapon. Yeah, I'm saying this is just it doesn't have a ring of truth for me. And that's the best I can say. That he was, he had her by her hands. He had her hands, and so she wedged her foot up against his throat, and he's trying to hold desperately to her arms while remaining conscious. And then just an instant before he lost consciousness from being choked out by this woman, that's when he decided to reach for his weapon. That just doesn't sound real to me. Hey, Kaiser Pineapple. Sorry, folks, got to bail. Duty calls. IT needs to work on our computers. Thank you for being here, Kaiser. So yeah, I just didn't like this whole shoe on the neck thing. It doesn't sound reasonably real to me. I just don't like it. And it just feels so exaggerated. This instance before he lost consciousness, he made his training kicked in, and he did this. His training should have been going the entire time. I don't like this. They wrestle and fight for 45 seconds, and then his training kicks in. His training should have been kicked in from the beginning. I thought this was a bad part of the opening statements for the defense, and I didn't like it, and I still don't like it.
Lost consciousness when that threat never stopped, ladies and gentlemen. Up until a split second before he lost consciousness, when my client's training kicked in, and he knew at that point he had to shoot until the threat was over. But she just tried to stand up here and tell you that Donna Castleberry wasn't an immediate threat. The evidence will show different. More on that later. Opening statements. As you heard the judge say yesterday, opening statements are an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or is the opportunity for us, me, to lead you down a path of what we believe the evidence will not show. Ms. Pritchard just stood up here and told you that this was out of retribution. Ladies and gentlemen, the evidence that you will hear will tell you differently. It's a roadmap, or preview, if you will.
Okay.
Now, every time Mr. Collins and I prepare for a case, we like to look what we call a theme. We like to examine what the theme of a case is, ladies and gentlemen.
Okay, I do like they're going to lay out a theme. I like that. They're going to give you the roadmap. That's kind of a cool thing, which you should be doing anyway. Excuse me while I cough here. Hi, I'm back. Mr. Enzo said if she was actively stabbing him, he would be dead. She wasn't continuously actively stabbing. He was engaged. According to him, he was holding her arms, which is and she's not complying. So the threat is still ongoing, is what he was saying. Super late and catching up. Hi, everyone. Hi, Drellon. Welcome. And Mavia, it's so nice to see the jury actually apply the law after all these other sham trials we're suffering through. Also, the prosecutor lady was annoying. Well, yes, she was. But that's just my view.
When you get a case, you have witnesses, some professional, some not. You've got evidence, some direct, some circumstantial, and those all sit on the periphery of a case. But what the theme of the case, ladies and gentlemen, the theme is what's left at the core fundamental concept of a case. The evidence will show, ladies and gentlemen, that the theme of this case is one of justification. That is because the evidence will show that on August 23rd.
That is absolutely true. That is the point of this entire case. Was what he did justified? Not what was she thinking? Not what was she actually doing? It's what did he perceive? And would a reasonable officer, a well-trained, reasonable officer, have done in the same circumstances, in the same situation?
2018, Andy Mitchell was justified when he made the decision to use deadly force. And that's because of those two components that Mr. Collins talked to you about in voir dire. First, that he had a subjective belief that he was in imminent fear of great bodily harm or death. And second, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene. Viewed through the
Okay, let's go through that step by step again, because that is the legal standard that we're looking at. And before we do that, we need to make another adjustment to Doggo Cam. There we go. We're edging closer. And as while we're stopped here, let's look at some of the monthly membership chat. Member for 6 months, Valhalla awaits. Member of 6 months for the Clean and Sober crew says, make sure y'all hit the like and make sure you're still subbed. Thank you very much. Couldn't have said that better myself. And American Dreamer, member for 1 month of the Clean and Sober crew. Thank you so much for being a member for 1 month, American Dreamer. I've been here 1 month. Seems like forever. Thanks for the entertainment, Jeff. I don't know if that's good or bad way of putting that. But anyway, let's look at these this one by one here. That didn't help. I need to bring up the right window. There we go.
And second, that belief was objectively reasonable.
Objectively reasonable. Objectively reasonable by what standards?
Based on the totality of the circumstance.
That's the whole picture, the totality of the circumstances, a big fancy lawyerly way of saying, look at the big picture, look at the whole picture. Don't miss the forest because of the trees. Look at all of the forest. Look at the whole forest, not necessarily the individual trees.
When viewed through the eyes of a reasonable
police officer. We, the jury, we have to put our minds into the mind of a reasonable police officer
on the scene.
So a reasonable police officer that is there in that situation.
Without the benefit of 20/20 hindsight.
And that's where I think a lot of the analysis goes wrong. I think that's where a lot of the analysis goes wrong. We can't look back and say, oh, this is what happened. We have to put ourselves in the position and watch this unfold and think, what was he doing while this was unfolding? What would a reasonable police officer in the same circumstances, at the same time, in the same location do? Would they do the same thing? Would they do something, or was it unreasonable what he was doing compared with other reasonable police officers? We can't look back and go, okay, well, it's clearly he could have done this. Clearly this happened. Clearly that happened. That's armchair quarterbacking it. That's Monday morning quarterbacking it. We got to be there on the line of scrimmage on Sunday while the game is on. That's where your mindset has to be. And I like that she did that. I don't think she emphasized that enough throughout the trial and in closing, though, because I don't remember this ever coming up again. But that's it.
Now, with the benefit of 20/20 hindsight, ladies and gentlemen, nobody disputes that this was a tragedy that occurred.
Good for her to acknowledge that.
2018, and it is certainly not lost on us that somebody lost a daughter, somebody else lost a friend.
It's good of her to say that.
However, just like Mr. Collins talked to you about in voir dire, the judge is going to instruct you that you cannot consider sympathy or empathy while examining this case.
Yeah, that sucks. Isn't proof of guilt.
It's a tough task, ladies and gentlemen, because undoubtedly the state of Ohio.
Now, Chandler kind of makes something interesting. Chandler Remington here in the Jet. Hey, Chandler. The physical limitations of a car make it hard to stab someone as enthusiastically as you'd like. If you wanted to stab someone, that is. See, I would turn that around. See, we have a lot of the people, that are like, oh, yeah, someone gets on my lawn, I'd shoot first and ask questions later. Someone breaks in my house, I don't care why they're there. I'll blast them and without thinking, which, fair enough. Or, in this situation, man, if somebody came up on me in traffic, or if someone, like the Perry thing, if somebody comes up on my car, man, I'll blast them. But it's a different story if you're like saying, someone is sitting an arm's length away from you and going with a knife. And you're not going to go, okay, I'd blast him or I'd take him out. No, I'd just get out of the car and put him in there. I don't know if that's intellectually honest. What do y'all think? You know, we're like, oh yeah, somebody comes up on my car and points a weapon in my general direction, I'm going to blast them. Or if someone does this, you know, if someone comes into my backyard looking around, I'll blast them. But we're not going to take that same I'm going to blast them approach when there's someone sitting arm's length away from you with a knife slashing at you. Yeah. I don't know. It's just something to think about.
Is going to try to use the fact that we are all humans. You're going to see that video. You're going to hear that audio be played time and time and time again. They're going to slow it down for you. They're going to play it, and it's sad, ladies and gentlemen. And we know you're human. However, Mr. Collins and I would ask you that every time the state of Ohio plays that audio clip, and every time the state of Ohio plays that enlarged video for you, you keep that instruction that the judge is going to give you in the back of your mind that you cannot consider empathy or sympathy. Those are not to
should have
be
hit
analyzed
hindsight again
when examining this case. Now, what you are to analyze and consider is what goes on within these four walls of this courtroom. And we believe the evidence will show, ladies and gentlemen, that Andy Mitchell was justified in using deadly force, and that's because it was reasonable. Now, unlike the majority of criminal cases here in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting their burden of proof. And it's
okay, so again, they have to prove murder. The state has to prove murder, or at very least, voluntary manslaughter. But this time, as Andrew Branco was saying, Ohio was the last state that put a self-defense argument in a position where the person claiming self-defense had to prove self-defense. So the state does have a burden of proof in this case to prove murder or voluntary manslaughter, but also the defense, by relying on a self-defense argument, has to prove that self-defense.
a high burden of proof, ladies and gentlemen, proof beyond a reasonable doubt. Now, that's the highest legal burden in our system. It is they that must prove to you each and every element of both crimes charged, felony murder and voluntary manslaughter, beyond a reasonable doubt. The judge will instruct you, ladies and gentlemen, that beyond a reasonable doubt is proof of such nature you would rely upon it in your most important of your own affairs. Care for an elderly parent, surgery for a child. Now, if they fail to prove each and every element beyond a reasonable doubt of those charges, then the judge will instruct you. Your analysis stops there. If they don't meet your burden, the judge will tell you your analysis stops there. You're going to hear two different theories that the state of Ohio is pursuing against my client. One saying that he shot to injure, that he knowingly committed a felonious assault, which proximately resulted in death. Second, that he acted in a sudden fit of rage or provocation, knowingly causing the death. Ladies and gentlemen, the evidence will show that the state of Ohio won't come close to meeting their burden of proof. And there's 4 reasons why. The first, they will not be able to meet their burden of proof beyond a reasonable doubt with respect to the mental elements associated with felony murder and voluntary manslaughter. The second reason,
I don't know how I feel about that. Okay, I feel they did not prove the mens rea, the mental requirement for the felony murder charges. I don't think they did that. The voluntary manslaughter, where you have to prove the that his judgment was instantly clouded by anger or a sudden provocative thing that just made him snap and do it suddenly. I know they talked about it a few times. Saying, oh, he got angry when she did, when she started resisting. He got angry when she started asking other people to come in. He got angry when he got stabbed. But I don't think they dwelt on the mental part of. I mean, they didn't. Okay, I'm going to say no. I'm going to say no. They didn't prove the mental requirements for voluntary manslaughter because they just said based on the tape, oh, listen, he got angry. All right, yeah, so okay, I agree with her on that.
Because the state's own witnesses will contradict one another.
Oh, they did that.
The third reason is
remember, I was laughing at that. I was like, oh, that's ha, ha, ha. Yeah, she's gonna do this. But actually, the state's witnesses did contradict each other. They even contradicted themselves a couple of times. The old dude did.
Because the state's own witnesses are going to contradict the physical evidence that is presented to you.
I can't think of anything off the top of my head where they contradicted the physical evidence. If there was something that sticks out in your mind, chat, is to where the prosecution where their explanation of the physical evidence was contradicted by experts. I don't think so. All right.
And the fourth reason is because of an expert that the prosecution is going to call. His name is Yuri Patrick. Listen, ladies and gentlemen,
Okay, Yuri Patrick is the guy that made me change from guilty to not guilty. So I will give her a direct bullseye hit on point number 4. Their expert Yuri Patrick was the guy that changed my mind from guilty to not guilty.
His name is Yuri Patrick. Listen, ladies and gentlemen, as he relies on false premises to come to his opinion. Listen as he ignores important, critical information. Listen, ladies and gentlemen, as he contradicts previous opinions and previous testimony that Yuri Patrick has rendered in the past. He wrote a book called In Defense of Self and Others. He has testified here in the state of Ohio in a seminal case. Listen as we go chapter by chapter in this book and point out contradictions of what he says in this book versus what he's going to tell you on that stand. Listen for contradictions in his prior testimony that he gave to a judge or a former jury with what he tells you on the stand. That's the fourth reason, ladies and gentlemen, that the state of Ohio is not going to be able to meet their burden of proof.
Okay.
Even if you find that the state of Ohio somehow does in fact meet its burden of proof, despite all the issues surrounding the mental elements, despite the fact that their witnesses will contradict one another, despite that the evidence will show that the witnesses contradict with the physical evidence, and despite this expert witness who's going to contradict himself on many, many levels, even if you find that the state of Ohio has in fact met that burden of proof, that's when you get to analyze our burden. And we welcome that burden, ladies and gentlemen, for it is proof by preponderance of the evidence.
All right, the old preponderance of the evidence. More likely than not, 51%, that kind of thing. But been there, done that. Says legal advice is what changed you from not guilty to guilty before that expert changed you back to not guilty. I was never thinking not guilty from the beginning. I was thinking guilty from the beginning. Just he changed me to not guilty.
And as the judge will instruct you, by preponderance of the evidence means more likely than not. That is our proof. It is certainly not as high as the state of Ohio's.
That is true.
He will tell you it is a smidge over 50%. So as you listen to the testimony, ladies and gentlemen, Remember, we have to prove the subjective component that it is more likely than not that Andy Mitchell had a belief that he was in imminent fear of great bodily harm or death. The second, the objective component, that it is more likely than not that his actions were reasonable.
And I like that because there's really no way you can disprove a subjective opinion. And because of that subjective opinion, that's why he had to take the stand. He had to get up on the stand and say, this is what I thought, this is what I believe, this is what happened, this was my frame of mind at the time. The subjective thing is easy to prove because you can't really disprove. You can't really say, well, that's not what you were thinking. But then you have the objective part, which is what would another reasonable officer, what would other reasonable officers do in those same situations? I like how she phrased that. It was kind of catchy.
Given the totality of the circumstances in the eyes of a reasonable police officer on the scene, going through everything that Andy did on August 23rd, 2018. Again, it's more likely than not. So I want you to keep those two questions in the back of your mind as you listen to the testimony, as you hold the state of Ohio to our burden, and then if you get to our burden, as you hold us to our burden. Is it more likely than not that Andy was in imminent fear? He was going to be harmed or killed? And two, is it more likely than not reasonable? We believe the evidence will show, ladies and gentlemen, that it was. Now, in any other case in the criminal justice system, the judge will tell you that typically you review these facts in light of your own experiences. That's not the case here. Your task, ladies and gentlemen, and it's not an easy one, is the judge is going to instruct you that you must view these facts through the eyes of a reasonable police officer on the scene. He's going to tell you that you have to examine the totality of the circumstances. And the judge will tell you, you cannot use hindsight in your analysis.
That's good of her. That's a good part of the argument to say what you said and then tell him what you said.
The judge is going to tell you that you're not to look at this, what this officer could have done, that he could have gotten out of the car, that he could have created time.
This is an important part. This is actually a very important part. You know, this is where well, he could have gotten out of the car. He could have done this. He could have done that. That's where this kind of goes out the window.
Could have done, that he could have gotten out of the car, that he could have created time, that he could have created distance, that he could have created space. But as the judge will instruct you, ladies and gentlemen, you are to look at what an officer could have believed about the decision to use force. Well, there's a reason why, members of the jury, that this is the law of justification. There's a reason why it's written in this fashion. And that's because unlike judges, unlike juries, unlike Miss Pritchard or myself, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and women on our police forces put their uniform on, they put their lives on the line, not knowing if they will return home to their families or their armchairs because they're doing their job. So that's why the law of justification is what it is. And you're going to hear all that. You're going to hear that on August 23rd, 2018, Andy Mitchell and other members of the Vice Squad had to be present at a shooting range for fire.
Okay, I don't remember her bringing this up. I remember them talking about it in evidence quite a bit. I don't remember her bringing up the shooting range in the opening statements. Okay.
Firearms training. This means that the entire unit went to the range earlier that day, took a refresher course on firearms. Present at the range was Sergeant Mike Evans, leader of the Vice Squad.
I'm the leader of the Vice Squad.
He's going to tell you they all drove separately to the range and proceeded with that training led by Officer Gagnon, who you also hear from. He led the entire unit, including Andy Mitchell, through shoot, don't shoot scenarios. earlier on August 23rd, 2018. 3 types of threats were presented to the Vice Squad during these training sessions. The first was a definite threat, second was a non-threat, and the third was an indeterminate threat. You're going to hear that when a threat was presented to the officer's training was enforced, that they are to shoot until the threat is over. Meaning, number 1, that the threat stops moving, and second, that the threat is no longer there. You're going to hear that Andy Mitchell was trained by Officer Gagnon on that day and participated in these shoot, don't shoot scenarios. Officer Gagnon is going to walk you through the protection that they use on the shooting range.
Yeah,
and
okay,
what
they
the
did all
controlled
that.
environment of the shooting range looks like. Listen, ladies and gentlemen, as he talks about the mechanics of how the range is designed. Pay close attention and contrast those mechanics logistically with that vehicle that you're going to go see. Think about how it would sound differently at the range versus at a car. He's going to tell you that you have to wear ear protection, that it's absolutely required at the shooting range. And that's because if a gun goes off, even in a controlled environment, at the shooting range, a person can suffer a loss of hearing. Imagine, ladies and gentlemen, what a shooting could look like or sound like in a confined space like that car
Really
that you're
loud.
going to go see, and what that would do to your ears. Also present at firearms qualifications was Detective Laura Evans, who you'll also hear from. The state is going to call her, and she'll explain to you what her directives were from her sergeant that day. That the group had decided they were going to go down to the west side to an area called the Bottoms in order to work prostitution. So the unit got in their separate vehicles and drove down to the Bottoms. They were working prostitution undercover, dressed in plain clothes, not in marked cruisers. You're going to hear that Andy picked up a woman who he suspected was a prostitute. He did this according to his training, something very common that the Vice unit did. He begins his audio recording so that he could record the interaction on a city-issued cell phone between himself and Miss Castleberry. Again, according to his training. You're going to hear that Donna Castleberry directed him where to go. Again, according to his training. You're going to hear that this training, if a police officer gets a prostitute in the car and you don't listen to where it is that she's directing him on where to go, that prostitute won't hesitate to jump out of a moving vehicle because that police officer would fail what's called the cop test.
Okay, I do have another critique of her. I do have another critique, and it's the same thing for the closing statements. The defense made very good arguments in in their opening statements and their closing arguments. They made very, very good points, but it's long. It's too long in both cases, I believe, in opening and closing. It's just too long. I like that the prosecution was tight, concise, and made their points. So I think she's losing points here, and she continues. Good Lord. I don't remember being that long. Oh, that didn't help at all, did it? Ah, crap. Let me go back and find that timestamp. Oops. Let's see. Where's that timestamp? Oh dear. All right, looks like it was at 45. All right. Oops. Hate when that happens. Danny did that today too, so I don't feel too bad. 45, that's good enough. All right. Yes, B. Jefferson, that's exactly what I said. All right, now see, some of you were pointing out something that I said as if it were a contradiction of my previous statements. Because I said going into this, I thought the prosecution was correct. I thought he had done this. I was on the prosecution's side until their own witness made me go not guilty. And people were quick to jump. They have been there, done that. Says, I guess when I watch these trials to assume the person is not guilty from the very beginning. Justin Smith says, nice presumption of innocence there, buddy. LMFAO. And MG Law feels so strongly about this. He said it twice here at 11:52 and then again at 11:59. But you have to start with not guilty unless the state proves guilt beyond a reasonable doubt. Something had to change you from not guilty to guilty before you changed back later. No, I'll tell you why that's not a contradiction of my insistence. I firmly maintain when you walk into that courtroom, you have a duty to assume that the police and the prosecution are going after an innocent guy. You have to believe he was falsely accused of the crime. I do that. I did that here. I think he's guilty, but whether I think he's guilty or not has nothing to do with the actual evidence presented at trial. So I have that presumption of innocence from the evidentiary point of view. As I say, in this case, I'm still not sure he didn't do it exactly the way the prosecution explained it. I just don't think they proved it. So I was pro prosecution. I was on the prosecution's side. I was thinking he was doing it going into this trial. But from a legal analysis point of view, focusing only on the evidence, I was completely swayed by the prosecution's evidence, by the prosecution's expert that he didn't, in fact, do it. So that's it. I'm saying we have what I believe to be the case and what the evidence shows to be the case. So that's the dichotomy that goes on in my head. This was not an appeal. This is a retrial. The first trial ended in a hung jury. They deliberated for 18 hours and couldn't reach a decision. So they retried it a year later. So, all right, let me not touch things too indelicately here. So 45, and all right, she goes for 15 more minutes. All right.
Police officer would fail what's called the cop test. So Donna Castleberry tells him where to park his car. You're going to hear, yes, that he did pull up to a pole. According to
this part, I think is too long and doesn't need to be in
policy,
the opening
containment
statement.
Policy of the Vice Squad back in August of 2018, so that they could prevent
You can just
the person who
emphasize
they were going
nothing
to arrest
did violated
from
department
getting out of the vehicle and running. You're
And just-
going to hear that was
badge. He wasn't required to have a badge.
to
Wasn't
his
required to have a walkie-talkie. Wasn't required to wear a uniform.
You're
Wasn't
going to
required to have a
that
car.
probable cause
He was. There's a cop
existed
test that,
for
you know,
Mr.
that
Mitchell
hookers
to
use to
arrest Donna
prove whether or
Castleberry
not he's a cop,
for solicitation.
and he didn't violate
You're
that.
going to hear her say $25 for the sex act, and then you're going to hear Andy say that he's a police officer.
Well, that's
He's
after
going to arrest
he
her.
fucked her up.
Again,
From 20
according to
5.
his training. He tells her, I'm going to put you in handcuffs. And that's for his safety, ladies and gentlemen, and her safety. Again, according to his training. Then you are going to hear the escalation by Donna Castleberry. You're going to hear her not comply. She refuses to answer his questions, and you're going to hear her resist arrest. The evidence will show that she has heroin on her person, that she is looking to score more dope after finishing her business. The evidence will show that she had a warrant out for her arrest.
Finishing her business.
Testimony will show that our client had to arrest her and take her to jail.
Because she had
his training. The evidence will show, ladies and gentlemen, that Donna
whoever
Castleberry
just
was
subscribed,
not going
thank
to
you.
comply with Officer Mitchell's arrest and then be taken into custody. So then you're going to hear and you're going to see that she starts scrambling, trying to think of anything to keep her from the inside of a jail cell, which again, ladies and gentlemen, you'll hear is not uncommon. She tries to say she doesn't believe that Andrew Mitchell is a cop. But ladies and gentlemen, you're going to hear that this was quickly debunked with all of the things my client shows to her, that he is in fact a police officer, but that he is working undercover. You're going to hear again that you're right. He did not have a badge on him that day. But again, ladies and gentlemen, that was according to his training because of a procedure and a policy that existed back in August of 2018 that undercover officers did not have to carry their badge on them.
They do now because they realized that was a bad policy.
You're going to hear that he provided her a Columbus police identification card with his picture on it. You're going to hear that he showed her handcuffs, the keys to the handcuffs. You're going to hear that a U-10-100, an arrest report, a complaint that is specific to the Columbus Division of Police was shown to Miss Castleberry. He says, I'm going to call my buddy.
I don't think they need, she's just going too long.
All of these things to show her that he was in fact a police officer and that she was in fact under lawful arrest. Then he tells her he's going to do a warrant check on her. He tells her, hey, as long as there's no warrants, I won't take you to jail. I'll issue you a summons and you can show up for the court date. However, again, ladies and gentlemen, according to policy and procedure as it existed back in August of 2018, if a warrant did in fact exist, Officer Mitchell had no discretion than to take Miss Castleberry to jail. You're going to hear, upon realization that a warrant check was going to be done, the situation escalated from non-compliant to violent in a matter of seconds. Donna Castleberry pulls out a knife. You're going to see that knife. It is not a small knife. She attacks my client with that knife. She feloniously assaults my client with a deadly weapon when he is buckled into that driver's seat of the Mitsubishi. She attacks him. And this was no small cut, ladies and gentlemen, as Miss Pritchard just tried to tell you. This was no small cut.
True. Yeah.
On his
I'm
hand.
glad she called him out on that.
This cut required 34 stitches. It required a tourniquet. It required an emergency blood transfusion and surgery. This was no small cut. Now, after she cuts my client, she continues to escalate the fight. She continues the attack and she won't stop. You're going to hear that she maneuvers herself so that her back is up against the windshield. You're going to hear that she placed her foot on my...
She's going again. She's bringing this up again. It's not necessary. All that, they showed her one of the forms that's exclusive to that. All of this is just unnecessary. I think she's kind of losing the jury. She lost me at the beginning, and she's kind of losing me now, even though I know how it all plays out.
My client's throat as he was buckled into the seat. You're going to hear that my client is trying to gain control of her hands, and as he tries to gain control of her hands, the harder her foot presses against his throat. You're going to hear that at the moment that he believes, right before he believes he is about to lose consciousness, Officer Mitchell makes the split-second decision that he has to and releases her hands, goes, unbuckles himself, unholsters his weapon, and fires to stop the deadly threat. You're going to hear that his training kicked in. He believed she still had the knife. She is moving all over the car. She comes towards him to get into the back of the car. He thinks she's going to slash his throat because he doesn't know where the knife is. That is what the struggle occurred for 47 seconds, what Miss Pritchard was talking about. She told you that it wasn't a split-second decision to use force. But make no mistake, ladies and gentlemen, while the struggle certainly did not last a split second, while it was not a split second that she went from cutting our client to choking our client, the decision to use deadly force, the evidence will show, was absolutely made in a split second. Now, the audio you're going to hear again and again, you heard, ladies and gentlemen, already. She says, I'm sorry. Okay. But the evidence will show that just because the audio recording heard that, just because you heard that, just because I heard that, just because Miss Pritchard, Mr. Cable heard that, does not mean that Officer Mitchell heard that.
That's a
in
true
that life or
statement.
death struggle. And ladies and gentlemen, the judge will tell you,
Barney,
you
stop.
cannot put yourself in Donna's shoes, not in Miss Pritchard's shoes, not in my shoes. You have to put yourself in Andy Mitchell's shoes as he was experiencing the deadly attack from the eyes of a reasonable police officer. You're going to go look at that car. Look at how small it is. Imagine that life or death struggle that I just described for you while in the driver's seat of that vehicle while he's belted in. Ladies and gentlemen, you're going to hear that the physical evidence that was recovered as part of this case matches the description of events that I just told you. Listen as we present that corroboration. Our burden, as you are listening to the testimony, remember it. Remember it as you hear all about the multiple felonious assaults on Andy Mitchell. Ask yourselves, is it more likely than not that he was in fear of serious harm or death, an imminent fear of serious harm or death?
Why you?
We believe the evidence will show,
That's
ladies and
wrong.
gentlemen,
That's mean.
that it is more likely than not that Officer Mitchell absolutely was afraid for his life. Ask yourself, is it more likely than not that his decision was objectively reasonable in light of the totality of circumstances through the eyes of a reasonable police officer? Now, how are you going to judge what a reasonable police officer would do on that scene? You've heard a lot of discussion about expert witnesses. You're going to hear from our expert, a man by the name of Kevin Davis. He's out of Akron, Ohio, he's been a law enforcement officer for almost 40 years. He's a certified use of force analyst. He's an instructor with the Department of Homeland Security and has impeccable credentials. Mr. Davis is going to take those facts that I just described for you in that life or death struggle, and he's going to help you apply them to the law. The judge is going to talk to you about factors that you are to take into consideration when determining and evaluating whether use of force was in fact reasonable. Keep these factors in the back of your mind. You'll hear testimony about them. You're going to hear testimony about the severity of the crime at issue. Evidence will show, ladies and gentlemen, that felonious assault is a very serious crime. The evidence will show that our client was attacked with a knife and then choked, a severe and violent attack. Evidence will show that the decision to use deadly force with respect to that factor while evaluating that factor was more likely than not reasonable. The second factor, whether Ms. Castleberry posed an immediate threat of physical harm or death to our client. Again, our client was slashed with a knife that required a tourniquet, 34 stitches, an emergency blood transfusion, and surgery.
I like that she keeps harping on that. We'll talk about that in a second.
Evidence will show that his decision to use deadly force in light of that factor is more likely than not reasonable. The third factor, whether Ms. Castleberry was actively resisting or attempting to evade arrest. You heard this already. The evidence will show that she was actively trying to evade arrest and continued to escalate the situation. The evidence will show that with respect to this factor, it is more likely than not that his decision to use force was reasonable. The fourth factor that you're going to hear testimony about.
See, this is like the third time she's told us there's 4 factors and things to consider.
You're going to hear that she was on cocaine, she was on fentanyl, a veterinary drug. You're going to hear that she consumed these substances no more than 3 hours before the incident. You're going to hear that she was non-compliant. So with respect to that factor, ladies and gentlemen, evidence will show that it is more likely than not reasonable. The fifth factor is the duration of the confrontation. Confrontation and attack lasted 47 seconds. And for 47 seconds, the struggle of life and death did not stop until Andy Mitchell shot to stop the threat. Evidence will show that with respect to this factor, the duration of the confrontation, that his decision to use deadly force was more likely than not reasonable. The sixth factor that you're going to hear testimony about is the possibility of a suspect being armed. Evidence will show, ladies and gentlemen, that this was no possibility.
I do like how, even though it's too long, I do like how she
Donna
keeps saying the
Castleberry
evidence
was
will
an
show, the
actual
evidence will show,
threat
the evidence will
on
show.
August
I like
23rd,
that.
2018. This was an uncontroverted fact, ladies and gentlemen, that on August 23rd, 2018, the evidence will show that Donna Castleberry was armed. When evaluating that factor, evidence will show that it is more likely than not that our client was in fact reasonable in his decision to use deadly force. Now, the judge is going to give you an instruction that says a mistaken officer can still be reasonable. So even if Andy Mitchell was in fact mistaken about exactly where the knife was in that vehicle on August 23rd, 2018, he's allowed to be mistaken, and the judge is going to tell you he's allowed to be mistaken, so long as you would find that mistake be reasonable. Again, ladies and gentlemen, we do not believe that the state of Ohio will be able to meet its high burden of proof beyond a reasonable doubt. Again, to hit those 4 points again, that's because the state's witnesses will contradict one another. The state's witnesses are going to contradict the physical evidence that was found. They're not going to be able to prove beyond a reasonable doubt the mental elements associated with the crimes they have charged my client with. And fourth, because of the expert, because of all of the false premises that Mr. Patrick relies upon. Again, members of the jury, even if you do find that the state of Ohio has in fact met their burden of proof, we believe at the end of the trial, we will have shown you that it is more likely than not that Andy Mitchell had a subjective belief that he was in imminent fear of great bodily harm or death when he made the decision to use force on August 23rd, 2018. We believe the evidence will show that it is more likely than not, when reviewed the totality of the circumstances, the totality of those factors through the eyes of a reasonable police officer standing in Andy Mitchell's shoes, that it was more likely than not reasonable. As such, my partner, Mr. Collins, will come before you at the end of trial and ask that you find Andy Mitchell not guilty of the crimes charged. Thank you.
Okay. All right. That's the opening statements. Well, shoot. What do y'all think? I like the prosecution's opening a lot better. Like a lot better. I thought the defense was too long. I thought she repeated unnecessary information too much. She said, you don't want to say there's four things you got to remember, then talk. Okay, then there's 5 things that you got to remember. Talk. Okay, now we're going to show you 6 things that you're going to have to look at. I didn't like that strategy so much. I would give her a C. Prosecution to me gets a B, B+. The prosecution gets a C for their opening statements. I definitely did like parts of it, but a lot of the parts you like get lost in the length and repetition and remember these 3 points, these 5 points, those 6 points. JSD says legal advice, but she has storytelling skills and easy to follow. State just lectured instead of telling a story. Yeah, I'll give you those points, but I think the storytelling went on a little longer than necessary. Like someone just posted on Twitter about I posted about seeing John Wick 4, and they said, well, they could have been an hour less gunfight and been the same movie. To which my response was, well, I didn't go there for an hour less gunfight. I went there for an extra hour gunfight. So this, it's kind of the same thing. She could have had the same closing statement, if not a better closing statement, opening statement. She could have had a better opening statement if she would have tightened it up a bit. Lost the repetition, didn't put so many standards in front of people, so many things to, it gets lost and bogged down. That's my feeling. What do you mean defense? Yes, I meant defense. I corrected myself. It's like a long story. Yeah, well, too long for me. Adriana says Valhalla awaits. I'm a mod. Okay, you've been one for quite a while. I don't know what the backstory behind that comment was, but I'm always amused. Long stories are better than short stories, says Kale Hyun too. Not always. In hindsight, at least the defense actually backed up the things they said. That is true. Brad says prosecution was better. Agree on grades. The prosecution gets a D- for the rest of the case. Well, I know you're pro prosecution in this case. I think that's being pretty harsh. I don't think even I would be that harsh on the overall job the prosecution did. Overall, I wouldn't give the prosecution better than a C for the overall handling of the case. Yeah. Mr. Enzo makes a good point. The number of stitches is irrelevant. They can do 14 stitches in a millimeter if they want. Well, that's a bit much at 14 in a millimeter. But also Brad says for a hand, you do extra stitches to provide better functionality. Well, I mean, that was one thing that I kept thinking as they were talking about that was, I mean, that's a lot of stitches. I have some pretty freaking gnarly scars on my body that didn't take 34 stitches to close up. The 34 stitches on the hand, that is reconstructive surgery. That's not just stitching up the outside of the skin. That's going down and reattaching, sewing up tendons and sewing up from the inside out, inside layers. That's a lot of stitches for a hand. I mean, weird. I don't even know if this will show up on the camera, but like that there from the motorcycle where I shattered both of my arms. Well, I didn't shatter I shattered this arm and just broke this arm. That took, I believe, 12 staples to close. And when I was younger, I got this scar was from when I was 10. I don't know if you can see it. It's kind of, because it was when I was 10. Kind of goes all the way around here. Yeah, it starts back here. Down at the sleeve. All right, let me show you my non-muscles. Yeah, this scar kind of goes down this way and comes back up to here. That was 27 stitches. I think this one here in my hand, it's like right there. Yeah, it's right there. I think that was like 4, 5, maybe 5 stitches. Yeah, nobody wants to see me take my shirt off. Trust me, Ghost White. I'm not going to show you the one on my leg, obviously, but that was 17 or 18 staples. So yeah, 34 stitches in your hand, that's reconstructive. But they were wise to do that. They made it sound a whole lot worse than it may have been. I mean, I know it was like deep and bloody and everything, but I think continually saying the 34 stitches makes it sound like, holy crap. When I think the majority of those stitches were likely reconstructive, and the state would have got nothing from going, it wasn't that bad of a cut, because they showed the cut and it was pretty damn ugly looking. So you'd say, 34 stitches is an exaggeration, or 34 stitches wasn't really necessary. It was the state would have got nothing from countering that. The most staples I've removed after a surgery is 152 staples. Good Lord, what, they just like make an entire skin suit and attach it? Holy crap. Chandler says, I went through your oldest videos and saw the one where you were in the hospital. You're a badass. Oh yeah, that was my leg when I shattered my femur. By the way, if your gas tank, your leg, and a concrete power pole come into contact with each other, the leg is going to lose every time. Just so you know. 152 staples, oh, good Lord. And I'll tell you that getting the staples taken out of this, that sucked because it was at a university hospital and it was training. They were training the nurses to remove staples that day. And the doctor's like, you're a tough guy, right? And I'm like, yeah. This is her first time taking staples out. And I'm like, oh God. And she would just like pulling on them like gently, and like just like pulling the flesh like this, just like pulling it, and I'm like, just pull the damn thing out. And so the doctor's like, yeah, just go, and then it got much better. But she was like trying to ease these staples out of my arm, and I'm like, no, you can stop that. So yeah, I was thinking the same thing, you guys that mentioned that in chat. The 34 stitches is reconstructive. And composer, it got the W, meaning the defense's arguments. I don't think the defense's opening statement got the W. I think, and I don't think the state's opening lost it. I don't think their closing arguments won it for either of them. I think this case boiled down to a solid battle of the experts. And in the battle of experts, the defense guy, Ken Davis, was that his name? Kenny Davis. Hell, I've got it over here somewhere. Kevin Davis ran freaking circles around Yuri. Yuri looked like an idiot, even though he supposedly wrote one of the Bibles of the self-defense books. He did not do well. Like I said, the prosecution's use of force guy, Yuri, he lost me. He lost the case in my head, and he lost the case. And then Kevin Davis came in and just nailed every single person that had testified to the wall and took out the prosecutor as well. So I think it was a battle of the experts, and the defense had the better expert by a damn mile. Great success, says in all caps, Jeff, you should get yourself a hand puppet for when you don't have any guests. Lol. There, thank you for shouting. Yeah. No. The dog was the star. Was he called Eddie? Yeah, I believe Eddie was the dog. Was it Eddie? If the experts switched sides, Patrick would have looked good and Davis terrible. The law and the facts were on the side of the defense. I don't know. That's kind of hard to speculate about, I think. If both guys had switched sides and they both believed what their expert testimony, that wasn't Kenny Rogers. If both of them switched sides and believed their testimony to be correct, I don't know. I think it's kind of hard to speculate how that would have turned out. But kind of at the the Byford Dolphin incident. Yeah. I'll say that the prosecution's opening statement wasn't as bad as I recalled it being. And the defense's opening statement was still as bad as I remember it being, even though I flip-flopped and switched sides. Well, what do y'all think? I'm curious. I know we've all made up our mind at this point, and nobody's going to be changing sides. We're not going to change sides here. I'm not trying to make anybody. Yes, I am trying to make people change sides because I think anyone that thought that verdict was justified was wrong. just saying. I did like the fact, and I mentioned it, and I'll mention it again because, hey, why not? I liked how the defense opening statement emphasized that you can't look at the woulda, coulda, shoulda. You can't look at that. You can't Monday morning quarterback it. You've got to put yourself in the mind of what that person was witnessing, seeing, and subjectively thinking. He told you what he was subjectively thinking. Then you have to process it from okay, what he was thinking, was that reasonable at the time? I like how they explained that. I thought that probably went a long way. So when I say that I don't think the defense's opening won the case, I think it probably could have gone a long way if they would have paid attention to that part. That you have to subjectively understand what he was thinking, then put yourself in the mind of an objective, reasonable police officer and see if what he did was reasonable. Not the only course of action, not the only possible course of action. Just, was it reasonable? And that standard is 50% or more. It's smidge over 50%, it was reasonable. So I think that's where I think the verdict comes in, and the verdict is correct. I think that subjectively, it's hard to disprove what he said. So I think we have to take what he said subjectively at face value. Say, he believed they did a long way to show that he probably couldn't have heard her saying, I'm sorry, whatever, after the shot went off in the car. That you get your tunnel vision, you focus on one thing, and you shut out a lot of other things. I think they showed that to the point where we have to say, okay, let's take him at face value that this is what he thought. And then, is it more likely than not that that was a reasonable action based on what he subjectively believed? And I think it was correct to say that someone that reasonably believed he was still under attack was reasonable in doing what he did. That's kind of my takeaway from the whole thing. And again, I want to say the guy is still probably a piece of shit. He's still probably a horrible human being. He's under the federal indictments for accusing him of doing here. But again, this was a different thing. This didn't seem to be he was trying to grape someone. He seems like he was trying to effect an actual arrest while on duty and calling other officers over. But he's under federal indictment for arresting them in flashing his badge and doing, give me a Hummer and I'll let you go. Things like that. So he's still probably a piece of crap. But it's the old, if the state does not meet their burden of proof, you must let them go, regardless of whether or not you believe, think, hope, wish, or desire that they were guilty. That protects the innocent people that are charged. And again, for the millionth time, it's better that 100 guilty go free than an innocent person be convicted. Well, Derna, if these charges were bullshit, maybe the federal charges are bullshit too. The victim one, the ones with victims, could be. I don't know. Well, they don't televise the federal cases, so we'll never get to see any video of the trial. We might get some transcripts, maybe. I don't know. Probably not. But the lying to the FBI, I doubt he'll get out of that one because the FBI probably has it on tape, and that was it's a kind of it's a weak thing to hang your hat on, but it is what it is. He was in an airport, and the FBI apparently asked him if he'd ever spent money on a hooker, and he said no, and I guess they have proof he did. So lying to the feds, he got a charge for that, and intimidating witnesses. I'm assuming I'm assuming. Man, we all know what that means. But okay, we'll just say that the federal cases have a higher conviction rate than the state because the feds usually do a lot more in-depth evidence gathering before they make their arrests and take people into custody and make charges. So we'll find out in July. His trial is scheduled to start in July. So there we go. Got a couple super chats here. And then what we're going to do is we're going to dump everybody over into Nicholas Starov's case. Russell, what do you think the state could have done better on to convict Mr. Mitchell? What were the shortcomings of the state? Good question. Again, one of the shortcomings is they didn't emphasize how long 12 seconds is to make 6 life-saving shots. They didn't do the cadence, showing the distance between the shots. I think that was a big mistake. To show them, just demonstrate how long 12 seconds is and how much time there was between the shots. I think they screwed up in losing contact with the single third-party witness that was around, the guy that walked out to the dumpster and threw some garbage away. So I think that was a mistake. Losing the one witness and go, yeah, that ID card looked real to me, or yeah, she was just screaming in the backseat, making a scene, or no, he was all over her and he was trying to do some creepy shit to her. They just lost that guy. They don't know where he was. They could have got a better witness, man. The expert witness was crap, was bad. And I think, I'm not sure who, was it John, Gary? Was you there saying you were watching the trial from last year and they had a different expert? They probably should have stuck with that expert they had last year. That's what I'm going to look at it probably over the weekend to see if maybe watching the first trial would be interesting. I don't know. We'll just have to see. I'll look at it and make a decision. But yeah, those are kind of some of the things I think the state could have done better. And again, I would like to have seen somebody testify which shot was the kill shot, which order the shots were fired in. But it's very likely that is something that could not have been proven. Which shots hit her and what order they were fired in. Well, yeah, Chandler was right. I remember them saying that this guy was really, really good on cross-examination. And people said that he just exploded and burned up and all these other bad explanations happened to him on cross-examination. But I thought he did a good job when he was scripted and doing his answers. But as soon as he went under cross-examination, he was crap. The expert witness was great on direct, terrible on cross. I always love to see it. Reminded me of Gross. Wow. Yeah, that was a bad cross-examination for him, wasn't it? Yeah. So the only time you blasted your arm off was when you pointed a gun at his head, right? Oh yeah. Russell, bringing a $5 super chat. Thanks for the answers. Totally agree with your analysis. The expert witness was bad. Yeah, he was bad. That was not a great expert witness to put up there. And I think we are good to go. Oh, we missed a couple here, a couple super chats. Where'd we go? Russell. No, we got to that one. Where are you, Marv? Wait, what? Okay. There was a Marv super chat we missed here. Where'd it go? Marvin 12:22. So got to scroll back 4 minutes. We'll do these super chats. We'll give a big hearty farewell to everybody and turn you over to Nicholas because I'm going to go join Nicholas. He's invited me to come on over there. Marv White, JW4 in IMAX was insane. Give me one more hour. They didn't have it in the IMAX here. They had it on the screen. It's called the Starium screen. At one point, it was the largest movie screen in the world. Like right across the river from my house. It's this gigantic screen. It's like 119. It's a huge ass screen. And that's what I watch every movie in because it's amazing. Yeah. So the bigger the screen for John Wick 4, the better. But the ending, I had a better ending. I wrote a better ending in my head than the movie ending did, but the movie ending was still good. It was still a good ending. It was a great movie. Just I would like to have seen my ending more. I think we've got over here American Dreamer. We got your 1 month here. Yeah. All right. That looks like we've gotten everything taken care of. And just for giggles, we didn't get doggo cam today. That's the first time we haven't got doggo cam, as a matter of fact, but that's no big deal. We'll just let you know they were all sitting here waiting the entire time for sleeping. Doggos are going to sleep. So say goodnight to the puppers. We'll bring them up next time when we get to the bonus round. If we get to the bonus round, join Chandler Remington and I tomorrow as we continue the OJ business. We're going to do OJ for the first time in 2 weeks. We skipped OJ because of this trial last week. So OJ tomorrow. Friday, probably do a little bit of legal roundup. There's been some developments in certain cases. There's been some other fun stuff happening. There's been some really bad courtroom stuff that videos we need to watch. So we'll have fun on Friday. We'll do it. I don't know if I'll do it Friday morning or Friday evening. I'm leaning towards Friday evening so that I can go out and Friday evening your time in the US, Saturday morning my time, so I can go and have some fun on Friday. And before we go, got to grift one little thing here, of course. It wouldn't be me if I didn't have something to grift. Law cards. GetLawCards.com/vices. GetLawCards.com/vices. This is just a fun thing that Farmhand Tom is putting together. Should be starting to ship soon. Oh my gosh, I got to send them the address too, because there's going to be signed cards from everybody. My cards are here. we got an F at Friday card. We got an unexplained card, and it's been confirmed that there will be doggo cards. There's going to be a strawberry Yoda card. So we'll be there. Steph, the Alter Nerd, Steve Gosney is the one that's spearheading this with Farmhand Tom. Andrew, Megan, Ricada's got his. Ms. Racket, she's got hers. Ozzy, I love his upside down card. That's good. But it's a fun thing to do. Gives you cards. We got Fight Milk. My Camelot impression isn't doing good today. I don't know. Guess I'm not tired enough to do Fight Milk. Get your Fight Milk and you get your Camelot card. Talk about NASCAR and racing and titties. Everybody got to talk about titties when you're on Camelcast. So yeah, we got the Fight Milk card and this handsome son of a bitch here. And these are some of my F at Friday guests. And if you go check on the QR code, we've got, it'll take you to one of the episodes that are featured on the cards. We got Steve's sidecar recipe on the back. And this is on professional quality collectible card stock. And there's going to be random stuff thrown in. Random signed cards. There's going to be what he's calling. My brain just went numb, which isn't an uncommon occurrence. Legacy cards, like the are they the legacy cards? But anyway, there's going to be like certain deals where you can like put in a code that will, if you're one of the lucky ones, you put in the code and you will get like an framed, encased, collectible quality piece of signed card from somebody. It's just a fun thing. It's $10 for a packet of 5. There's 24 separate packets that are going out. It's just something fun that he's doing. The Fight Milk recipe should probably get a 1 star. 1.5 is a bit much for Fight Milk. Anywho, it's a fun thing. It's just something that he did there. Go to getlawcards.com/vices. Order now. And you'll get your cards. I've ordered an entire set just because I think it's hilarious. I think it's something fun to do. And I just love that I made the front cover. All right, that's enough of that little grift there. That's just something fun. Shipping is going to be starting very quickly on that, I hope. Probably in the next few weeks. There you go. That's it. And Dragon's Treasure tea, if you want to do some of that. TheDragon'sTreasure.com. Code VICES gets you 10% off your tea. You get a discount. I get 5% kickback. And T-Man, he gets a sale. You need cards signed with Yoda and strawberry paw prints. Oh, that's kind of fun. That's a good idea. I'll pass that along to Tom. That might actually be fun. That's actually a good idea. All right, I'll tell him that more than one person brought it up. See, Chandler, she just got her tea the other day from the Dragon's Treasure. I'm making my second cup, and it's amazing. I love the tea. I drink it myself. And on that note, let's all go say hi to Nick. Let's go say hi to Nicholas, not Ricada, Nicholas Starov. We're going to automatically filter you over there. We'll be here tomorrow at 9 a.m. Eastern for OJ Simpson, more funging around. And let's see what our poll ended up today. Today's poll ended up 8% of you said you want to get me to 37,000. 22% of you said you want to get me back to 36,000. 24% of you said just settle down, keep it to 36,000. And 46% of you said you wanted to get me to 50,000 subs. Well, let's see how we did on numbers today. We started out at 986 and we're at 989. We picked up 3 more. Cool. At least we're getting closer back to the 36. Thanks, guys. Love you guys. You are so awesome. I'm deeply appreciated. You're all here. I appreciate the engaging conversations. You guys make me think. I hope I make you think a little bit. And if somebody accidentally learns something factual, hey, that's a bonus on both sides of the coin. Thank you, mods. Thank you, chat. Vice Squad, you rock. Thanks for the super chats that came in. Thanks for your generosity there, and we'll see you tomorrow. Larax reminding you to whatever you do, make sure you enjoy your legal vices. Go on over to Nicholas and say Legal Vices sent you.